You just got off the phone with the bank. Your mom died, and they told you that they can't talk to you until you have letters testamentary. And you don't know what that means. But here's the thing. The bank might actually be wrong. There's a good chance you don't need letters testamentary at all. It depends on the situation, but there are all kinds of ways where that may not be the case. And I'm going to talk to you about those today. Hi guys, my name is Dan Schnurbusch. I'm an estate and probate attorney out of Missouri. We help clients all across the state of Missouri when somebody passes away in dealing with probate and estate administration. Here's what the bank actually means when they say that. Their bank representatives and people that work at the bank, they're trained to tell you stuff like, we need letters of administration, we need letters testamentary. But that's just code language that says we need you to go to probate, okay? That means we need to have somebody that has legal authority to make decisions on behalf of this piece of property, okay? And what they know is letters testamentary and letters of administration are two ways to deal with that, because they have policies that go all across the United States, and they can't worry about the technical terminology in every 50 different states, okay? Now, that being said, letters testamentary and letters of administration are the most common concepts that you will hear when opening an estate. It is a very common concept. Banks and lots of people are familiar with. So that's what they ask you to provide in order to show proof that you are allowed to manage the property of the estate. And the reality is that letters testamentary and letters of administration are not always the document that you need to show the proof of the right of control that you need in order to access and deal with the property of your deceased loved one. So here's what letters testamentary actually are. Letters testamentary is the document that is issued when somebody had a will and you go to court and the will has been admitted to probate. What the court issues when you are appointed representative are called letters testamentary. Only when the person had a will. And that's essentially your fancy seal of authority to manage the estate property. This is the document given to the executor or personal representative of the estate. Normally it's referred to as a personal representative in the state of Missouri, but many people are familiar with the concept of an executor. Now, you may have been asked for letters of administration, and these are the exact same thing, except they're issued whenever there is no will. So you have letters testamentary when a will does exist and is admitted to probate, and letters of administration when there is no will, okay? That's the difference. So what do letters actually allow you to do? It allows you to do anything that the deceased person could do, essentially, in managing and winding up their estate. So opening a bank account, selling property, paying debts and creditors, dealing with and managing the property as if you were the deceased person. Okay, so you essentially step into their shoes in the winding up of their financial affairs. Now, here's why the bank might have been wrong. In Missouri, there are at least 3, and a bunch of also special cases. There are at least 3 ways to go through probate, as in addition to a bunch of other special cases. Okay, and the main one that requires letters of administration, or that letters of administration or letters testamentary are granted through, is a traditional full probate administration. Okay, so this typically in Missouri lasts somewhere between 10 and 14 months. Can be a little bit shorter, can be longer, but that's kind of generally the timeline. This is a full proceeding when the property value exceeds $40,000 and it is less than 1 year from death. Okay, this is kind of the traditional probate administration that most people have in mind when they think about, I need to go to probate. This kind of probate can be either supervised or unsupervised. There can be a will or no will. But this is the largest and most involved version of probate in the state of Missouri. It's the longest and most expensive as well. So if you can avoid it through some other method to satisfy the bank or whomever it is that you need to prove that you have the authority, it is often a good idea. So that's track number 1. Most people assume they're in track number 1. Banks and brokerages assume you're in track number 1, but that is often not the case. Track number 2 is the small estate affidavit. All right. In Missouri, this can be used anytime anytime the total value of the estate is less than $40,000, after subtracting any debts and liens. So for example, let's say you have a house worth $70,000 and you have a mortgage on it worth $40,000. Well, the net value there is $30,000. So that's below 40 and therefore would qualify potentially for small estate treatment. Okay. Whenever you have a small estate, you're not issued letters testamentary or letters of administration, and you don't need them. Under Missouri law, the statute explicitly grants the affiant, or the person who files the small estate affidavit, the same authority as if they were appointed with letters of administration or letters testamentary. The same authority to deal with a deceased person's property, and that includes things like gathering up bank accounts or selling vehicles and so on. A small estate procedure usually takes anywhere from a couple of weeks up to a couple of months, much shorter, much cheaper, much faster than a full probate administration. So if the bank says, hey, we can't talk to you until you give us letters testamentary, you might talk to a probate attorney, and the attorney might say, well, the bank account is only 30 grand. There's no other property, and therefore we can get a small estate done in a couple of weeks, and you can take this to the bank, and they will then release the money to you that way. So that's another method that sometimes when the bank says you need letters, there's often another shorter method that you can take instead. Now, sometimes banks still don't understand what they're looking at when they see the closing order in a small estate case. It's called the certificate of clerk in a small estate. And for that reason, we actually have a comprehensive letter that we've put together that we send to banks that basically explains the law in Missouri, and here's how it works, and please give the money to our client. Actually, Missouri actually has a law that if they refuse to give the money to you under appropriate circumstances, you can actually sue them for the distribution of the property, and that's usually sufficient to scare them into making sure that they give over the money. All right. Now that's track number 2. Track number 3 is called a determination of heirship. This is a different kind of probate case when it's been longer than 1 year from death, and the value of the estate is usually larger than $40,000. Okay. In these situations, we often need to look at doing a determination of heirship. So like, let's say you have a bank account or an investment account, and it turns out it's worth, $60,000. That's beyond the small estate threshold. If it's been longer than 1 year since death, we can look at doing a determination of heirship. Different kind of probate case. In this situation, what we're doing is we're filing a petition with the court. We're going to get a hearing. We're publishing in the newspaper. We're showing up at the hearing, putting on evidence about the assets and the estate and the heirs. And we're getting a court order that declares who the heirs are and what property it is that they're entitled to. Okay? So in this kind of situation, you get an order determining the heirs. You don't get letters of administration. In fact, it's not legally possible. So if you have a bank telling you you need legal letters of administration and it is beyond a year from death, they're definitely wrong, because you cannot legally get letters of administration or letters testamentary in Missouri after 1 year of death, unless there was a will that was already filed inside of a year. Very uncommon situation. So it's almost not worth mentioning, but there are rare exceptions to that. There are other exceptions relating to personal injury, certain kinds of personal injury cases, but for the most part, it is not legally possible to obtain letters of administration or testamentary beyond 1 year of death. That's when we're looking at this determination of heirship procedure. Generally much shorter. Instead of a year, we're usually looking at a few months to get the publication out and get the hearing set into the future. The publication has to run for several weeks before we're allowed to hold the hearing. But that's generally how the track number 3 runs in the state of Missouri. And that will produce that order, the same kind of order that you'll get in a small estate case that you should be able to use to collect up any assets that are listed on the order without having to get letters testamentary or letters of administration. So those are the 3 tracks. Letters testamentary, letter of administration, and you need in a full probate case when the value is over $40,000 and it has been less than a year from death. A small estate might be what you need if it's less than $40,000 and at any time after death. If it's more than $40,000 and over a year, we're probably looking at a determination of heirship. There are some special cases too. If you're a spouse or a minor child or a creditor, you may be able to claim the estate if it's under $15,000 to $20,000, $24,000 if you're in St. Louis County, depending on who you are and how long it's been since someone's passing. Okay, those also would allow you to claim the bank account if it is small enough in the state of Missouri. Those are called refusal of letters applications. We'll talk about those in a different video. So let's suppose you have a situation where there is a will and it's less than a year from death and you actually do need letters testamentary. What does that look like? Well, in this kind of situation, we first need to get the will admitted to probate. So we'll need that original will. We file it with the court in the county where the person was living at the time of their death, usually. And the will, assuming it is valid and has the requisite signatures and is otherwise not subject to contest, will be admitted to probate by the judge. If it has signatures but is missing a notary, there may need to be commissions issued to get the sworn statement of the witness in order to admit the will to probate. But assuming you have everything that you need, the will is admitted to probate, and that makes the will kind of the binding and authoritative document governing the administration of the estate. So whoever it says is the representative is the person entitled to apply for letters testamentary. Okay? Generally, there won't need to be any kind of court hearing. If the representative is the person who applied and it is a valid will and it's admitted to probate, that person, and they do apply as representative, they will just be appointed representative, and then the heirs of the estate are notified and given the opportunity to object if they wish. Once the letters testamentary are issued, you will need to prepare an inventory of the estate property, but from that point forward, you'll be able to go ahead and contact banks, brokerages, deal with the estate property. In many cases, if you have letters testamentary, the will is going to control what you're allowed to do. You may or may not need any court supervision. Generally, you don't. Occasionally, the will not allow for independent administration, but is extremely rare. Most of the time, a will allow for independent administration, so you won't need to go to court and talk to a judge every time you need to sell something or pay for something, and so on. Do you have to hire a lawyer to get letters testamentary, letters of administration, determination of heirship, small estate? Generally, yes. In most counties across Missouri, you are going to have to hire a lawyer. There are for any kind of probate other than refusal of letters. If you are in certain more rural counties, it is more often the case that you can get through a small estate case without an attorney, but for a determination of heirship or a petition for letters of administration or letters testamentary, you will have to have a lawyer by Missouri law. How long does it take? As I discussed, in a open and full administration, it'll generally take between 10 and 14 months. In a small estate case, it will generally take between a couple of weeks up to a few months. Can take longer if there are reasons for delay. There are all kinds of different reasons there could be delays, usually court-related, but generally a small estate is much faster. A determination of heirship is usually 2 to 4 months, depending on the length of publication and any other complications that may arise. So what should you do right now? Don't assume that you necessarily need letters of administration. You need to talk to a probate attorney in Missouri to figure out what needs to be done. Because remember, that is when the bank says you need letters testamentary or letters of administration before we can talk to you. That's code language for you need to go to probate. And like, let's say you want to file for small estate or a determination of heirship or something, and they still won't talk to you. What we can do to get information about the account is to send a subpoena. And that's essentially just a court order to produce records. So even if no representative is being appointed and they still feel like they can't talk to you about the account, what we can do is, again, send that subpoena to get court-ordered production of records, and we can use those records to answer our own questions. So what you need to do is if you got a letter from a bank or a brokerage or anybody or a life insurance company that says you need letters of administration, letters testamentary, that is code that says you need to go to probate. Talk to a probate attorney, and they'll be able to give you more guidance about what to do next. If you want to talk to me and talk to our office, there's a link in the description where you can we'll screen you and you can book a consult to talk with me. Or a member of our intake team, okay? Otherwise, just call the office at 314-246-0578. Again, the number's in the description, and we'd be happy to chat with you and see if we'd be able to help in your situation. Remember, none of this was legal advice. This is just legal information. If you want to understand how this applies to your particular situation, give us a call, and I'd be happy to talk through it. If you have a question, go ahead and drop it in the comments. I do read them. I try to respond to them to the best I can without giving formal legal advice. But go ahead. So again, this is Dan Schnurbusch. I hope you enjoyed this video. If you are interested in following along or want to show your appreciation, go ahead and like and subscribe for the algorithm so that other people looking for these kinds of things can find us. That's it for this one. I'll talk to you in the next video, guys.